Now that we have learned about the Constitution and its origins and federalism in America, we transition into Chapter 4 where we learn about civil liberties. Now, I want to take a moment to urge you to keep in mind that although many people use the terms civil liberties and civil rights interchangeably, they do have two separate meanings and two separate definitions, so it is important to keep that in mind as you move through the chapter. By the end of Chapter 4, you will be able to describe the Bill of Rights and how it came to be applied to state governments as well as the national government. You will be able to explain how the First Amendment's Establishment Clause and Free Exercise Clause guarantee our freedom of religion. You will be able to specify the limited circumstances, including obscenity and slander, in which the national and state governments may override the principles of free speech and freedom of the press. You will also be able to provide the constitutional basis for the right to privacy and explain how the principle has been applied to abortion and the right to die controversies. You will also be able to identify the constitutional rights of those who are accused of a crime, describe the Miranda and exclusionary rules, and cite examples of how recent security concerns have affected our civil liberties. Restraints on the actions of government against individuals are generally referred to as civil liberties. Again, restraints on the actions of government against individuals is generally considered civil liberties. The first 10 amendments of the U.S. Constitution, the Bill of Rights, set these restraints on federal government. The most famous is the First Amendment, which provides for freedom of religion, speech, the press, to assemble, and to petition the government. Now, it's important to think back to Chapter 2 and remember that the Federalists believed that the Constitution without the Bill of Rights was sufficient, but those anti-Federalists were very wary of any strong central government. And as such, they insisted on some type of protections, some type of rights that would protect the individual rights of people. And so if you value things like freedom of speech and freedom of the press, then you want to keep that in mind because we owe a lot to those anti-federalists for insisting on this Bill of Rights. But we also owe a lot to the Federalists because they were willing to consent and include this Bill of Rights. The framers created a brief document with broad guidelines in structuring the Bill of Rights, knowing that the courts would interpret it over time. It places limitations on the government, thus protecting the citizens' civil liberties. Disagreements continue over the meaning of simple phrases such as freedom of religion or freedom of the press, as well as its power over the states. Now, certainly, you are aware that at the time that the Constitution was written, there wasn't an internet and there wasn't television, and the primary way in which people received news and information was the few newspapers in the nation. And now nearly every small town has a newspaper. So we have seen the expansion of freedom of the press just as a natural progression of time. While the Bill of Rights protected the people from the national government, it didn't protect the people from the state governments because remember, this is a federal law. And part of what was essential at the time that the Constitution was being drafted was that state governments be able to maintain their autonomy and control over the daily lives of their citizens, that states be able to make their own laws. In 1833, in Barron v. Baltimore, we see this confirmed. Most states had their own bills of rights, meaning that people in different states essentially lived with different civil rights. In 1868, the 14th Amendment was ratified and constitutional protections of civil liberties began to be applied to state governments. In 1925, with Gitlow v. New York, the Supreme Court began to apply specific rights depicted in the Bill of Rights to state governments. But incorporation theory, or the idea that most protections of the Bill of Rights were incorporated into the 14th Amendment, has never been fully accepted by the Supreme Court. The First Amendment addresses the issue of religion in two venues. The first venue is separation of church and state, and the second is the free exercise of religion. The First Amendment states that Congress shall make no law respecting an establishment of religion. The Establishment Clause prohibits the creation of a church that is officially supported by the national government. It creates a wall of separation between the church and the state. In 1971, in a case Lemon v. Kurtzman, the Supreme Court ruled that state aid could not be used to subsidize religious instruction, and its three-part Lemon test is often used to determine these types of questions. Such aid is ruled out by the Establishment Clause, but the court has permitted aid in some limited situations. One ongoing controversy is whether school vouchers can be used for religious schools. Some states attempts at education reform involve granting students vouchers that can be used at any public or private school, including a religious school. The court has ruled that this is permissible. Nonetheless, some state courts have held that vouchers violate state laws. Now, the distinction here is that if a school is a private school or a faith-based school, as long as its primary purpose is not to instruct in religion, then those schools are eligible for federal aid. So that's the distinction. But the question continues to be whether or not school vouchers can be used outside of the public school. Now, the reason that this is an important question is many people, parents, members of the community, believe that ultimately they should decide where their children go to school and where their tax dollars are used to subsidize their child's education. In 1985, the court ruled in Wallace v. Jaffrey that a minute of silent prayer in schools was unconstitutional, but the lower courts have interpreted this to mean that a moment of silence is permitted when it has a secular rather than a religious purpose. So this really means that if you take that moment of silence to pray to any God or no God, to meditate, to review terms for your American government exam, to take a 60-second nap. Any of that is acceptable as long as you are not asked to stand for a silent prayer. In 1968, the court held in Epperson v. Arkansas that no state can ban the teaching of evolution because this would impose religious beliefs on students. But likewise, the teaching of intelligent design in public schools was strongly criticized by the federal court and ruled unconstitutional in 2005. The court has also ruled that nativity scenes and the Ten Commandments are acceptable displays on public property if they are part of a broader or secular display. In 2009, the court ruled that a city in Utah was not required to accept and display a religious monument from a group, though the group based its argument on freedom of speech and not the Establishment Clause. These high school students pray around the flagpole before classes in Lufkin, Texas. Do their actions violate separation of church and state? That's a good question to think about. As this is before school and not affiliated with the school day, not disruptive of the school day, and not led as an organized prayer by the school, it does not violate separation of church and state, as it is student-led, and students have the right to pray. Congress also prohibited from passing laws that deny people the right to express their religious beliefs in the Free Exercise Clause. But the Supreme Court has allowed for some restraint on specific religious practices that interfere with public policy. So examples are vaccination requirements regardless of religious beliefs. Also, churches and other religious institutions have a tax-exempt status, so they are not allowed to endorse candidates or make campaign contributions. Now, members of a church may make campaign contributions, but the church itself cannot. Meaning churches, can take positions on ballot initiatives. But in practice, the IRS rarely bothers to respond when churches do make endorsements, although they did respond in 2010 to several churches that had endorsed conservative candidates to the Tea Party movement. The right to free speech and free press are two of the most important and frequently invoked freedoms of Americans, the right to have our say and to hear what others say. Censorship by restraining an activity before the activity has actually occurred is called prior restraint. Only on rare occasions has the government been allowed to stop the press from printing anything. If the publication violates a law, the law can be invoked only after publication. In the New York Times v. United States case of 1971, the Supreme Court ruled in favor of a newspaper's right to publish information that the government wanted to be prohibited from publication. This was known as the Pentagon Papers. Signs, gestures, articles of clothing, and other types of nonverbal expressive conduct that convey meaning are considered symbolic speech. Now, symbolic speech is not without complete restriction, but it is constitutionally protected by the court. In the Tinker v. Des Moines case, the court ruled that wearing black armbands was protected speech against the Vietnam War. However, many schools have implemented various dress codes that restrict the wearing of certain clothing, colors, and phrases that might be extremely offensive or invoke violence. The controversial act of burning the American flag was ruled as a form of free expression in Texas v. Johnson in 1989. This led Congress to pass the Flag Protection Act, which was then struck down as unconstitutional by the court. In a 2003 Virginia case, the Supreme Court ruled that burning a cross can be banned as long as the state can prove that the intent of burning the cross was intimidation. Now, this is an important question to think about. Why would the court rule that burning a cross can be banned if it's done to intimidate, but not make the same ruling about the American flag? It's also important to keep in mind the time in which court cases are handed down. There are quite a few years between 1989 and 2003. Advertising statements are considered forms of commercial speech, which had no protection historically. Restrictions must meet substantial government interest and go no further than necessary to meet the objective. Advertisers can be held liable for factual inaccuracies in ways that don't apply to non-commercial speech. So this particular advertisement here for cigarettes, which was published in 1946. The headline is, "More doctors smoke Camels than any other cigarette." Now, that's kind of a free pass or encouragement almost to smoke cigarettes. You would never see an ad like that today. In fact, it's pretty rare to see an advertisement on the news for cigarettes. However, because this would be considered something that could cause public harm, right? The government would have an interest in ensuring that that does not take place. They could restrict this type of advertisement. In 1919, the Supreme Court allowed restrictions on speech that allegedly would cause harm to the public. That is, when a person's words present a, quote, clear and present danger to peace or public order. Thus, the clear and present danger test was established. The court has modified this rule over time. In 1925, in Gitlow v. New York, the government received greater power to restrict speech through the court's enunciation of the bad tendency rule, marking the first time that it invoked the First Amendment against a state government. In 1969, in Bradenburg v. Ohio, the court established the incitement test, which allows for restrictions on speech only when it is likely to incite or produce lawless action. This is difficult for prosecutors to prove, but the famous example here is that you can't yell fire in a crowded theater or a crowded building, as it would cause panic, unless there is a fire, and then you can warn people. The Supreme Court has often grappled with the legal definition of obscenity or sexually offensive material. In 1973, the court ruled in Miller v. California that material can be legally obscene if it violates the four-part test established by the court. Material is obscene if it, 1, the average person finds it violates community standards. 2, the work as a whole appeals to the prurient interest in sex. 3, the work shows patently offensive sexual conduct. Or 4, the work lacks serious literary, artistical, political, or scientific merit. The court also stated the nature of prurient interest would be determined by the community standards, therefore avoiding defining obscenity and opening the way for widely differing interpretations of the Miller v. California case. Now, certainly what was considered offensive in 1970 might not be considered offensive today. So the court left room for this to evolve over time. In 1984, the Child Protection Act made it a crime to knowingly receive mail with sexually explicit depictions of children. In 1990, the court ruled in Osborne v. Ohio that states can ban private possession of child pornography. In 2008, the court upheld a law that makes it a crime to offer child pornography even if the pornography in question doesn't exist. Congress has made many attempts to shield minors from pornography on the internet, but most have been ruled unconstitutional by the Supreme Court. In 1996, the Communications Decency Act banned the online availability of any obscene or indecent messages to minors. It was struck down as unconstitutional as an infringement on free speech the following year, because the terms indecent and patently offensive could refer to a numerous number of materials that were not pornographic. Similarly, in 2004, the 1998 Child Online Protection Act was struck down by the court as a violation of free speech. The court has upheld the 2000 Children's Internet Protection Act, which requires that public schools and libraries install filtering software to prevent children from viewing adult content, because the filters can be removed at the request of an adult. Defamation of character involves wrongfully hurting someone's reputation with false statements. Slander involves the public uttering of oral statements that are false and are intended to defame the character of another. Libel involves such statements in writing. Now, the key here is where you say this information and whether or not the purpose is to defame the character of another person. However, if what you say is defaming to another person, but it is a true statement, that is not slander. Court rulings on this form of free speech have often been based on the level of schooling involved, with the least rights being granted to elementary students and the most rights being college students. Now, court rulings on this form of free speech have been based on the level of schooling, and that means that your ability to speak freely and to express differing opinions will increase as you transition through school. High schools can impose restrictions on speech that would not be allowed in college settings. This was upheld by the court in the controversial 2007 decision regarding an Alaska high school student, which supported the power of the school officials over student speech. Now, in this case, Morse v. Frederick. At a school-supervised event, Joseph Frederick held up a banner with the message, quote, "Bong hits for Jesus," end quote, a slang reference to smoking marijuana. The principal, Deborah Morse, took away the banner and suspended Frederick for 10 days. She justified her actions by citing the school's policy against the display of material that promotes the use of illegal drugs. Frederick sued, and the federal civil rights statute, alleging that a violation of his First Amendment right to freedom of speech. The district court found no constitutional violation and ruled in favor of Morse, the principal. The court held that even if there were a violation, the principal had a qualified immunity from lawsuit. The U.S. Court of Appeals for the Ninth Circuit reversed this decision, citing Tinker v. Des Moines, stating that students have the right to the First Amendment and their speech is protected. Furthermore, the principal did not have any qualified immunity because a reasonable principal would have known that Morse's actions were unlawful. The Supreme Court, reversed the lower court's decision in a 5-4 ruling stating that school officials can prohibit students from displaying messages that promote illegal drug use. Chief Justice John Roberts' majority opinion held that although students do have some rights to political speech, even while in school, the right does not extend to pro-drug messages that may undermine the school's important mission to discourage drug use. So you would not have the ability to promote an illegal activity, but as a student in school, you don't lose all of your rights to freedom of speech. Colleges may distribute such funds among student groups as activity fees, even if the groups have beliefs that many students or some students at the college would reject. In 2000, the court favored a Wisconsin university's right to require fees even if they were used to support social or political causes that some students might disagree with. State university behavior codes are designed to prohibit hate speech, which attacks people based on their ethnicity, race, or some other criteria. Federal courts have generally found such codes to be unconstitutional, but many still exist. A librarian at a middle school in Durham, North Carolina, holds up The Lorax by Dr. Seuss. Some people demanded that the book be removed from school libraries because it allegedly portrays foresting and the foresting industry in a negative way. Why do some people believe that it is appropriate to limit what public school students can read? Should it be appropriate? Should it not be appropriate? Should there be restrictions based on the age of the student? Freedom of the press is similar to freedom of speech. Although the press was limited to printing material when the First Amendment was proposed, technology has added new ways to disseminate information, so related laws have been modified. Libel is defamation of character in writing as well as in pictures, signs, films, and other communications. Public officials must meet a higher standard than ordinary people to win a libel suit. In the New York Times County v. Sullivan case of 1964, the Supreme Court held that actual malice must be involved for libel of a public official to occur. So the Supreme Court indicated in this ruling that if you are a public official, you have to actually prove how you were harmed by the images or pictures or words that were printed about you. Now, that does not apply to private citizens. The standard has since been widened to all public figures, so this includes public officials, celebrities, movie stars, or anyone who places themselves in the public limelight. In the 1970s, judges increasingly issued gag orders restricting the publication of news stories about a trial or pretrial hearing to protect the accused's right to a fair trial. In the Nebraska Press Association v. Stewart case of 1976, the Supreme Court ruled that the gag order violated freedom of the press, but it has since upheld gag orders in certain cases where publicity could be harmful to the trial. Films were once routinely censored, but in 1968 the court ruled that they could only be banned if they were proven to be obscene. Radio and television broadcasting has the least First Amendment protection. In 1934, the Federal Communications Commission was established to regulate the airways and license the use of the airways. This allowed it to impose rules and administer sanctions. Some language, such as filthy words, is not allowed in broadcasts, even though that is not necessarily considered to be obscene. Why is a political protest a guaranteed liberty in the United States? What did protests hope to accomplish? And at what point does a protest become unlawful? You can watch that video here. Now, there's no explicit constitutional right to privacy, but it is an interpretation by the Supreme Court. The basis for this right comes from the First, the Third, the Fourth, the Fifth, and the Ninth Amendments, as established in the 1965 Griswold v. Connecticut case, in which the Supreme Court ruled that prohibiting the use of contraceptives violated the right to privacy. Historically, abortion was not considered a criminal offense until the quickening, or the first movement of the fetus. But by the mid-19th century, state laws had become much more restrictive, and by 1973, performing an abortion at any point in the pregnancy was illegal in most states. In 1973, the court held in Roe v. Wade that governments could not totally prohibit abortions because this violates a woman's right to privacy. It ruled that government action was limited depending on the stage of the pregnancy. In the first trimester, states could only require that only a physician perform an abortion. In the second trimester, it could only be to protect the health of the mother, and states could specify the conditions under which the abortion could be performed. And in the third trimester, states could prohibit abortions. In later rulings, the court twice struck down the requirements for counseling before abortions, but in 1992, it allowed those requirements plus a 24-hour waiting period. Prenatal or judicial permissions my apologies, parental or judicial permissions for minors, and bans on government funds for performing abortions. Now, the controversy continues. Anti-abortion forces continue to push for laws banning abortion. They endorse supportive candidates and they organize protests. In 1994, the Freedom of Access to Clinic Entrances Act banned protesters from blocking entrance to abortion clinics. In recent years, opponents have focused on state ballot initiatives to restrict abortion, laying the groundwork for the challenge to Roe v. Wade. But defeats in Colorado and South Dakota have proven this to be unsuccessful. In 2000, the Supreme Court invalidated a Nebraska law that banned partial birth abortion, or intact dilation and extraction, a second trimester procedure. In 2000, legislation similar to Nebraska's was passed into law by Congress, and in 2007, the court upheld this law, reversing its earlier position on partial birth abortion. In the first highly publicized right to die case involving Karen Ann Quinlan, the New Jersey Supreme Court in 1976 ruled that patients or their families had the right to refuse treatment. In Cruzen v. Director, the Missouri Department of Health, in 1997, the Supreme Court ruled that a patient's life support could be withdrawn at the request of the family member, but only with clear and convincing evidence that the patient did not want the treatment. What if there is no living will? These rulings have led to the popularity of living wills, or a durable healthcare powers of attorney. In the Terry Schiavo case in Florida, it was determined that for married persons, the spouse is the relative with the authority in the matter. The Florida legislature then passed a law allowing the governor to overrule the court, but the state Supreme Court said this was unconstitutional. Now, if you are unmarried, ultimately your family would make this decision if you do not have a durable health care power of attorney. So that is something to think about if you are involved in committed relationships but are not legally married, or if you just want to have someone that isn't your family to make those tough decisions in the event that you are unable to. The courts have historically upheld state laws prohibiting physician-assisted suicide. In 1996, in Washington v. Glucksberg, the Supreme Court said that the Constitution does not include the right to commit suicide, assisted or otherwise, but left the decision on permitting the practice to the states. Since then, Oregon, Washington, and Montana have legalized physician-assisted suicide. If the government accuses an individual of committing a crime, the individual is presumed to be innocent until they are proven guilty. The accused is allowed specific rights and may be set free on a legal technicality related to their violation. The Bill of Rights, specifically the 4th, 5th, 6th, and 8th Amendments, set forth the specific rights of criminal defendants. The rights of the accused. The following rights are afforded to criminal defendants. Limits on the conduct of police officers and prosecutors, such as no unreasonable or unwarranted searches or seizures. No arrest except on probable cause. no coerced confessions or illegal interrogations. They must be informed of their rights at the time of the arrest, and no entrapment. Defendants' pretrial rights are the writ of habeas corpus, prompt arraignment, legal counsel, reasonable bail, to be informed of their charges, and to remain silent. Their trial rights are a speedy and public jury trial, an impartial jury representing a cross-section of the community, a trial atmosphere free of prejudice, fear, and outside interference, no compulsory self-incrimination, adequate counsel, no cruel or unusual punishment, appeal of convictions, and no double jeopardy. Now, during the 1960s, the actions of the police and prosecutors were limited while the rights of the accused actually expanded, including the right to an attorney if the accused could not afford one. This was decided in 1963 in Gideon v. Wainwright. In 1966, in Miranda v. Arizona, the Miranda ruling requires that the police inform the suspect at the time of their arrest that they have the right to remain silent and the right to an attorney, and that if they cannot afford an attorney attorney will be provided to represent them. The court spelled out the very familiar wording of the typical Miranda rights statement. There are some exceptions to the Miranda rule. Those included a 1991 ruling where coerced or illegally obtained confessions need not bar a conviction if other evidence is strong. So if there is evidence outside of what was obtained without that Miranda warning, then that does not indicate that the case will be dismissed due to that technicality. Since 1914, a judicial policy called the exclusionary rule prohibits the admission of trial and any illegal evidence that has been obtained. This includes evidence obtained in violation of the Miranda or the Fourth Amendment, which is the protection against the unreasonable searches and seizures, and requires a search warrant. It was later extended to the states in the Mapp v. Ohio case of 1961. In recent years, the court has created exceptions. Examples are if the evidence would have been acquired anyway, or if an arrest was made in good faith. As we've seen, greater rights and liberties extended to individuals. We have also seen major security issues in the past 20 years. Now, if you remember from Chapter 1, we talked about this constant conversation between freedom and security, between liberty and order. Privacy rights have taken on particular importance since the terrorist attacks of 9/11. Anti-terrorist legislation has eroded certain basic rights, including the Fourth Amendment protections against unreasonable searches and seizures. One issue involves legislation authorizing roving wiretaps. A person under suspicion can now be monitored electronically on any electronic device. This contravenes the Supreme Court's interpretation of the Fourth Amendment, which requires a warrant describing the place that will be searched and also prohibits general searches. The Patriot Act, which was enacted in October of 2001, eased restrictions on the government's ability to investigate and arrest suspected terrorists. For the first time in history, it allowed the government to open a suspect's mail. It also expanded its ability to search the suspect's home and monitor the suspect's online activities, phone conversations, financial records, and book purchases. Opponents of such rules argue that it violates a number of constitutional amendments. Shortly after 9/11, secret surveillance and monitoring, including wiretaps without warrants, was allowed for the National Security Agency through an executive order. 4 years later, a secret program was reported by the media and criticized by civil liberties groups. In 2007, Congress passed a law that authorized warrantless NSA wiretaps. It expired and was reauthorized in 2008, but only after much debate. Now, what's important here is that under the Fourth Amendment, you have the right to privacy. However, if there is a concern that a person might be sympathetic to terrorists or have ties to terrorism or radicalism, then they sort of lose most of those rights under these acts, which again was enacted after 9/11 and extended after 2008. The terrorist attacks of 9/11 strengthened the belief that the civil liberties of non-citizens should be limited. The Bill of Rights does not state that its protections are limited to citizens, but the 14th Amendment does say that all persons shall enjoy due process of law. Illegal immigrants are subject to deportation, but in 1903, the court ruled that this could only occur after an actual hearing. Despite the wording of the 14th Amendment, the courts have often ruled that non-citizens cannot make constitutional claims. Laws passed in 1996 allowed for the deportation without court review or based on secret evidence. In Reno v. American Arab Anti-Discrimination Committee, the court ruled that non-citizens, even permanent residents with a green card, have no right to object to deportation. The Constitution prohibits ex post de facto laws, those laws that would punish acts that were not illegal at the time they were committed. Under the 1996 laws, this does not apply to non-citizens. This brings us to the end of Chapter 4. Keep in mind that, as I mentioned at the start of the lesson, although we often hear civil rights and civil liberties used interchangeably, they do have different meanings. Restraints on the actions of the government against individuals are generally referred to as civil liberties. In Chapter 5, we will define and discuss civil rights.